the lower courts to go through and carefully look at every allegation and ask whether it falls within the presumption of immunity. They also iterate that the government bears the burden of showing that certain acts are not entitled to immunity. Now, I also happen to think that many of the allegations in the indictment are obviously not within the outer perimeter of the president's official duties, but the reality is that by writing the opinion this way, they have made it harder for the lower court to proceed to trial and harder for the lower court to allow much of the indictment to proceed as well.
All right, so we are resetting. It is 11 a.m. here in New York. The Supreme Court has just handed down its decision on presidential immunity. Again, it's a mixed bag decision. There's some presidential immunity. There's presidential immunity for official acts, not for unofficial acts. But the way that they've worded it, as we've been discussing at this table and with our guests, is that it does seem to lean heavily toward Donald Trump's arguments here that he can do what he wants to do as president of the United States. Let's bring in NBC's Ken Delaney outside of the Supreme Court. Ken, what do you have?
Yeah, Katie, I think the analysis here has been spot on. You know, the decision goes a long way to say that the president is not above the law and that private acts, unofficial acts, are not immune. But if you look at what the implications for Jack Smith's indictment of former President Trump, they appear to be dire, because there's a whole section in the indictment about Donald Trump's efforts to enlist the Justice Department to allegedly falsely proclaim that there was fraud in the election, write letters to states. That is completely out, according to this decision. And then you get to his conversations with Vice President Mike Pence, which are a key part of the indictment. This decision says that there's a presumption that those are immune, but that prosecutors could seek to rebut that in the lower courts. And then it also says that his public statements, the public statements of any president, are largely immune. And so the speech at the ellipse, any social media, the tweets, the Truth Social posts by Donald Trump about January 6th, that is largely out of this case. What is possibly remaining in the case are Donald Trump's and his allies' conversations with state officials, with private parties in their effort to get state officials to conduct investigations into bogus allegations of fraud. And what this decision says is that all that has to go back down to the district judge, who has to scrutinize in close detail every single one of these allegations and decide what constitutes private conduct, what could possibly be official acts. And then, of course, that's appealable. And so the idea that this case could go to trial before the election is completely out the window. That's not happening. And in fact, it could take a year or more to sort through this stuff, even if Donald Trump doesn't win the election and this case still goes forward. This Supreme Court decision greatly complicates this major indictment of Donald Trump by the special counsel, Katie.
There's a little more that I want to read from page 32. Again, Lisa directed us to pages 30, 31, and 32 before. Here's an interesting portion of it. This is the majority opinion. This is Chief Justice Roberts writing. Trump asserts a far broader immunity than the limited one that we have recognized. He contends that the indictment must be dismissed because the impeachment judgment clause requires that impeachment and Senate conviction precede a president's criminal prosecution. The text of the clause provides little support for such absolute immunity. It states that an impeachment judgment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. Chuck, can you interpret that for me? Yeah,
this was an argument that Mr. Trump's lawyers put forth. I thought it was, I think the technical legal word for it, Katie, is silly. It was never going to get any traction in the courts of the United States. The notion that he had been impeached in the House but acquitted in the Senate would preclude a criminal case against him is nonsense, and the court is saying as much. I just want to add one note of caution. If you look at the underlying indictment against Mr. Trump, much of what is alleged is private conduct, and it's alleged to be unlawful. Based on my reading of this opinion, that stands. You're shaking your head in my peripheral vision. So
yeah,
go ahead, Andrew.
I disagree. I agree with you before the decision came out. The court, though, goes through the allegations in the indictment, and they say the DOJ matters are out. They're core. But then it says,
I agree with that.
But with everything else, it says that there is a presumption that they are official.
So you shook your head a little bit too quickly, because what I was going to say next was they're still in. they are going to be the subject of the hearing. The judge will have to apply these new standards to determine whether or not they survive or not. But they might. And before we decide that the indictment is dead or Mr. Trump is going to walk, we ought to see what happens at the hearing below when Judge Chutkan tries to apply these standards to the allegations in the indictment. But Andrew's right. It makes it much harder. I don't disagree with that at all.
I want to bring in Maya Wiley as well, but Lisa's trying to jump in. So, Maya, just hold on 1 second. But hold on a little bit before. Tell me what you're thinking now, because I have a follow-up question to something that Justice Barrett disagreed on. But go ahead.
I want to put my voice in with Andrew's choir here and to say this is much more of a disaster than it might seem based on the rules that are being carved here, and for two reasons. One, at oral argument, John Sauer for former President Trump acknowledged that the fraudulent elector scheme was what he would describe as private conduct, and despite that concession in the majority opinion, they're saying that still lives for another day to determine whether or not that's private. That's conduct that Chief Justice Roberts expressly describes among the buckets of stuff that Judge Chutkan still has to weigh whether it's private or official, indicating that they think it might be official. The second thing, and Katie, this is a big deal, is on page 18. There's a big paragraph in terms of the guidelines for Judge Chutkan in determining what's official and what's unofficial. And they say, the majority, in dividing official from unofficial conduct, courts may not inquire into the president's motives. This was a huge issue at oral argument. Chief Justice Roberts asking John Sauer, what about bribery? Let's say former President Trump or a president appoints somebody to an ambassadorship and gets a whole bunch of money for that. Are you essentially saying that we can't consider the bribery, but we can consider the acceptance of the money? That's tautological. That's nonsensical. And despite that, they are now carving a rule out that says the motive can't be considered. In other words, if you appoint somebody to an ambassadorship, it doesn't matter whether you're doing it for your own private gain. That's still official.
How can they write an opinion that says that? How can that be?
I don't know how that can be, but I want to be really clear with what we are seeing here. And I want to go back to Neil's comments. This is not so much an opinion as it is a broad edict meant to serve a particular moment, even while they say they are
writing a rule for the ages.
Writing a rule for the ages.
This is a rule for the moment. Let's bring in Maya Wiley, officially civil rights attorney, former assistant U.S. attorney, and president of the Leadership Conference on Civil Rights and Human Rights. Maya, give us your top-line thoughts. Come into this conversation. Welcome.
Thank you. My top-line legal thoughts are cray-cray. So I was right there with Andrew, and I love Chuck. And I want to read it the way Chuck is reading it. And I actually had what I was going to jump in and say exactly what Lisa just said about the motives point. So why don't we just go back for a minute to what the indictment alleges? Because that's what makes it so clear that this is such an, in so many other ways, there's so many things we could say, but remember that this indictment starts even on the first conspiracy, on conspiracy to defraud the U.S., going step by step about every executive in the Trump administration appointed by Donald Trump telling him he lost the election. That's how the indictment starts. Literally, DOJ, Homeland Security, his cybersecurity appointee, who he then fired, everyone, including, and then you could talk about the private side, his campaign manager, telling him he lost the election, and that in Arizona, which is the first of the 7 states that is, run through in the indictment, says all the things Donald Trump directly did, despite being told there was no evidence of the things he was pushing an Arizona elected officials on. And by the way, what is the official act of a president about how a state is executing its elections? Calling up personally. So I agree with Chuck. If you were reading this in the way, I actually think the fact that we're even talking about this, when we look back at U.S. versus Nixon, where Jaworski actually had every assumption he could prosecute Nixon, didn't because he thought it was a bad decision, not because he didn't think he could do it. You even had U.S. senators in the Trump impeachment think that he could still be indicted, which at least at that part.
Mitch McConnell said so.
Mitch McConnell said so. At least the Supreme Court says that. But go back to the fact that they wrote this opinion the way they wrote it on the facts of this indictment makes it so clear to me that it is not written for the ages.
Let's bring in Neil Katyal. Neil.
Yeah, I want to return to this point from the dissents about the impact of this decision today on our democracy. And, in response to Chuck, and Chuck's absolutely right, the majority says there'll be case-by-case hearings to determine whether something is an official act or not. I just don't think, and I agree here with the dissent, that that's any sort of protection here. We've never needed those kinds of case-by-case hearings before. We've always just assumed a president is not above the law. And in these hearings, these case-by-case hearings, as Lisa points out, you can't even introduce any evidence of a president's motive, why he was trying to do something like pressure the Justice Department or do whatever. And there'll be a presumption in favor of the president. As Justice Jackson says, that's just ridiculous. And here's what practically this means. A president, like Donald Trump next year, or whoever the president is, can take a blatantly illegal act, slap the label, hey, this is an official act, and write that in the preface to whatever the heck he's doing. And now we're going to have hearings and so on before district judges and then appeals to determine whether it's truly an official act or not. And it'll all take place against the backdrop of this Supreme Court decision, which says when you pressure, if you're the president and you pressure the Justice Department to throw out or to impugn an election results where you obviously have the greatest of personal motives, that's not a personal act, that's an official act. So if that's your standard for what is an official act, much else is going to be official. And what does this mean practically? I think it means if you're Joe Biden, if you're a Democrat who's running for the president, your path right now is clear. You have to run against the Supreme Court. You have to run against this decision. This is not America. If you want to make America great again, you got to return to the rule of law. This decision today, unfortunately, is a blueprint on how to end the rule of law.
Are you arguing adding justices to the Supreme Court?
I'm not arguing adding justices. I'm arguing that we need to have justices that are consistent with the rule of law and with the most basic American tradition of which no person is above the law. And, I think, unfortunately, the dissents are right here in saying this really changes the nature of our entire government and presidency.
Neil, but running against the Supreme Court, these are life appointments. So unless a couple of them decide to resign or something happens, you're not going to get another appointment, and you might not get one in the next 4 years. What about, there is impeachment. That's a possibility for justices. It's a long shot, but it's a possibility.
Yeah, I'm not saying anything like that. I am saying, though, that I think much attention has to be given to what this decision will do to our separation of powers, to our rule of law, as well as the decisions from last week in Dobbs and the like. This court now seems pretty out of step with mainstream American society. The idea that a president